of State, nor members of Parliament, nor lawyers, and who shall be appointed by the Chief Justice on the advice of the Council of State. She wants this to apply, Council.
No. So the reason it won't apply once again is this. One, as I've already said, in her own case, when it came to the ruling on the matter, okay, so that's the when her ladyship, Justice Gertrude Torkono, plaintiff applicant against Attorney General and the chairman of the committee. In that case, when you listen to the ruling of the Supreme Court, and that's Justice Tanko, let me read it. He says, I need hardly say that I arrived at the conclusion that this application must fail without relish, mindful of the fact that the applicant, the Honorable Lady Chief Justice of the Republic, is going through a process that may define her career on the bench as Chief Justice and as a judge, one way or the other. You see it? And then when you go to a J2, the same thing. They cannot be decoupled. No, no. And even so, with what the Chief Justice is actually seeking, then now maybe she wants a proper interpretation, so-called. You see, in law, to be fair to her, sometimes they can say that, oh, the matter that was before the court in a J2, Derry, and then this Justice Torkono herself versus AG and Scott Wama did not directly answer the question. There was no issue before the court that when you are removing CJ, are you also removing the CJ as a judge of the Supreme Court? Yes, there is that kind of argument that can be made, all right? Sure. But if you do that, that's why I said, then the first ground that should have been attacked is that because the Supreme Court has already given this interpretation in a number of those cases that it affects her as a person both as CJ and as a judge of the Supreme Court. So if the Supreme Court decisions are not persuasive enough, then the argument, she can make the argument, the first argument she should have made is that in the Constitution, the grounds for the removal of a Chief Justice have not been provided. Do you get the point I'm making?
Yes, indeed.
There are no grounds for removal of a Chief Justice in the Constitution. What is there is the grounds, that's the basis on which you can remove, are for Superior Court justices. Because that's the only way that this new argument she's making will make sense. Then also, there's a point that then this High Court decision case actually requires an interpretation of the Constitution. And so if that is the case should go to the Supreme Court, not the High Court. The court can make a determination that it does not affect her as a justice of the Supreme Court. That will require detailed interpretation of the Constitution. And if that is so, then the High Court is not the proper forum. The case has to go to the Supreme Court. The High Court judge cannot do what Justice Torkono is asking for. No, it can't. It cannot be done in the High Court because that's a complete interpretation of the Supreme Court. And the High Court is not clothed with jurisdiction to do what is being sought there.
I see. So you say her argument or her case or grounding, if this particular relief was with respect to her removal as Chief Justice, because that is not clearly stated in black and white in Article 146.
Yes, it's not in there. It just says grounds for removal of Superior Court justices. And the Chief Justice is a justice of the Superior Court because she's a judge of the Supreme Court. Okay? Yes, so that's why it is court. But to say which part of the Constitution says if you want to remove the Chief Justice, these are the grounds clearly stated, no. Rather, you'll find in the J2 where the Supreme Court was explaining Article 146 and then gave some flesh, not total, but some flesh to the meaning of stated misbehavior, blah, blah. It said the Chief Justice can be removed, this. But that's in the J2. And I'm saying that it's the same J2, and in this case, her own case against Attorney General and Justice Scott Wama, where they said if you are removing the Chief Justice, you are removing the Chief Justice as a Supreme Court judge. So what I'm saying is that if she has accepted that a Chief Justice can be removed, even though the grounds were not stated in the Constitution, but rather in a jail, etc. Then she has also accepted the same judgments that have said that when you are removing the Chief Justice, you are also removing the Chief Justice as a Supreme Court judge, because you can't approve it. In law, we say you take, okay, and then reject. No, there's inconsistency, because all of these statements are in the same cases. So why do you go into those Supreme Court decisions, then you pick and choose and leave others? That's going to be difficult.
I see.
Yeah, so it's either you reject all or you accept all. But to pick and choose, this cherry picking, no.
I see. So the potency of the warrant of her removal, you say, can actually apply in both cases as Chief Justice and also as a Superior Court judge?
Absolutely. Because the Supreme Court has said that when you are removing the person as a Chief Justice, you are also removing the person as a Supreme Court judge.
Because in the warrant, the third relief that she's seeking, that's one of the questions she's asking, in fact, a declaration of, that the warrant of a removal executed by the president, purporting to remove her from both offices, is really unlawful. She says it's null, void, and of no effect. Counsel.
Yes, so we'll still come back to the same point. The Supreme Court says that it affects both, not once, at least twice. Maybe after tonight, I'll check in Derry, the Justice Paul Derry case. I don't think that one. But in the Jechum and in Justice Torkono's own case, the Supreme Court says it affects both positions. So that's why I made the other point that then in that case, if she wants to throw out these statements, in other words, to say what in law we say obiter, because she said that that was not the main question before the court, all right? It was collateral, or it was, yes, there was just some comments in passing. Then, in that case, if you said that was obiter, so how did you accept that a Chief Justice can be removed even though the Constitution does not prove the grounds, or the Constitution does not state the grounds? I find it difficult to reconcile this. Yeah.
We'll see how the coming days will look like on this matter. Counsel, I thank you. I appreciate you as always. Thank you. She herself as well presided over, and how the outcome of those cases, in his view, also goes contrary to the position that has been taken now. We'll see how this case flows. But as I indicated, this is a stone that is really gathering dust as we go on. But this is one we'll keep an eye on here on Ghana Tonight. But coming up next, let's still stay on the matters of law, because Ghana's deportation Rabbi Torkono has filed an application challenging her removal by President John Dramani Mahama, not as the Chief Justice, but this time as a Justice of the Supreme Court. She contends that the President's use of the warrant to remove her from the office of the Chief Justice cannot be extended to remove her as a Justice of the Supreme Court. Now, we've been monitoring how this has been developing, and in the motion, which was filed through her counsel, Justice Torkono is seeking multiple declarations, and we're going to get into that shortly. A number of reliefs that she's seeking as well, including the many multiple declarations as well that she is asking for in the grounds of this particular application that she has then filed. In fact, she's indicated a number of things, that the President acted outside the powers conferred by the 1992 Constitution when he issued a removal warrant on September 1, 2025, which stripped her of both the office of the Chief Justice and as the Justice of the Superior Court of Judicature. Now, this matter, on the same day, September 1, if you recall, the early afternoon of September 1. That was when the decision of her removal was communicated by that letter from the presidency, signed by Phyllis Kwachofosu, that the president acted upon the recommendations of this 5-member committee. Before they would end that day, we got a copy of this warrant that she talks about. So these are the reliefs that the former Chief Justice is seeking in this fresh application, which, we understand, was filed today. Take a look. A declaration that the president is devoid of power to remove a justice of the Superior Court from office without recourse to the mandatory procedure set out in Article 146 of the 1992 Constitution. So the president cannot do that without a reference to that mandatory procedure. And so what is this mandatory procedure that the former Chief Justice talks about? That she goes into some specifics in the Relief B. A declaration that jurisdiction to hear a petition for the removal of a Chief Justice of the Superior Court from office lies with a body properly constituted under Article 1464. She says that that power to remove the justice of a superior court from office lies with a body properly constituted under Article 1464 of the 1992 Constitution. So what does Article 1464 of the 1992 Constitution specifically state? And it's one that we'll get into shortly. Also, she is seeking a declaration that the warrant of removal executed by the president dated 1st September 2025 purporting to remove the applicant, that's Justice Torkono, hearing from both the office of the Chief Justice and the office of a Justice of the Superior Court of Judicature is unlawful, null, void, and of no effect. In fact, all of these, and there are a few more reliefs that she's seeking, all of it is reflected in the sentiments that she expressed about this entire process, even before her removal. And let's recall that press conference that she addressed and the sentiments that she expressed, because it's captured in the last two reliefs, which we'll get into shortly. But take a look at this.
Unfortunately, every step of the removal process being undertaken against me is being done in a manner that breaks every rule on how justice is delivered in our country. And this is why I find the need to draw the nation's attention to the serious violations of the Constitution and law in the process, and the danger it holds for the development of the nation's democracy. Unfortunately, every step of the removal process being undertaken against me is being done in a manner that breaks every rule on how justice is delivered in our country. And this is why I find the need to draw the nation's attention to the serious violations of the Constitution and law in the process, and the danger it holds for the development of the nation's democracy.
And this is the warrant that she wants quashed, essentially. No, go put that on the screen. This is the warrant that she references in the reliefs that she's asking for. This is the warrant that the president, in fact, wrote to Justice Gertrude Eraba Sabat Torkono, sealing the entire process of her removal. Now, therefore, know ye all men that I, John Dramani Mahama, President of the Republic of Ghana, in pursuance of the said Article 1469, do hereby remove the Chief Justice, the said Chief Justice, Justice Gertrude Araba Esaba Saki Torkono, from the office of Chief Justice and Justice of the Supreme Court. So it is the second part of the power of this warrant that the former Chief Justice is now challenging, because this warrant removed her from office of the Chief Justice and Justice of the Supreme Court with effect from the date hereof, that's 1st September, in witness whereof I have hereunto set my hand and caused the presidential seal to be affixed at Accra this 1st of September 2025. That is what underlines this fresh application from the former Chief Justice. Martin Pebble is private legal practitioner. He's joining us on Zoom right now for a conversation on this and beliefs that the former Chief Justice is asking for. But Martin Pebble, looking on the face of this particular warrant, and as I read that the president issued, which essentially removed the former Chief Justice from office of the Chief Justice and Justice of the Supreme Court, the fresh application now is questioning that power by the president to remove her from office as a Justice of the Superior Court. Now, you've seen the reliefs and the grounds right now. I want to first of all find out from you, is really, from where you sit, how this strikes you and whether it reflects exactly what the position of the law is.
Yeah, so, Mr. Kansi, my first comment is that when I saw, I wasn't seeing, I heard the information, okay, on a radio station. I was flabbergasted, extremely surprised that we could have this new kind of litigation. I'm extremely surprised because, you see, that's if we go straight into it. When you look at Article 146, right, there is only one provision that deals with grounds on which the Justice of the Superior Court may be removed from office, and that's Article 146 Clause 1. So my point is that there is no other place in Article 146 that you specifically find grounds for the removal of a Chief Justice. There is none. There is none. When you go to 146, you won't find that the, what do you call it?
Yes.
There is any other provision so the point is this. If Chief Justice Torkono is saying that she was not removed as a Supreme Court judge, then I would have expected that when she went in there, she should have challenged the grounds to say that the Constitution does not even make any grounds at all for the removal of a Chief Justice. If she had made that, that would have been more plausible, because when you look at it, of course, there's a Supreme Court decision that says that administrative functions, blah, blah, blah. But she's going by the wording. The reason I'm saying that she should have raised this argument is that in 146, you don't find a specific provision that says that the grounds for removal of a Chief Justice are incompetence, stated misbehavior, and the infirmity of mind and body. There's nothing like that. So that is what she should have raised first, because this new lawsuit sounds in a literal reading of the Constitution. But when you read the Supreme Court decisions, Ejechum, and then this recent one, her own case, you see Justice Tanko making the point that her removal as Chief Justice also affects her removal as a Supreme Court judge.
I see. But then she references in the reliefs, and counsel, if you permit me, and this specific one that she is asking for, that this declaration that the jurisdiction to hear a petition for the removal of a Chief Justice of the Superior Court from office lies with a body. She said there has to be a body essentially properly constituted under Article 1464 of the 1992 Constitution to actually take or hear or has that jurisdiction to hear the petition for the removal of the Justice of the Superior Court and not the Chief Justice. So if you look at 1464 that she references, It says where the Chief Justice decides that there is a prima facie case in the instance of the removal of a superior court judge, he or she, in this case she, shall set up a committee consisting of 3 justices of the superior courts or chairman of the regional tribunals or both, appointed by the Judicial Council, and 2 other persons who are not members of the council